Welcome to you both, Sereca from the Hood and Katie Ashby Copens. You're coming in from where, Katie?
From Australia.
I first heard about you as this legendary woman, this lawyer who was giving advice to Sereca and helping get this almost impossible thing over the line, which you did so well in Wellington last week. Just give us a quick update to start, Sereca, on what happened, because there was a huge amount of interest in the case when it went in Wellington last week.
Well, we spent the Monday and Tuesday last week, so 27th, 28th in Wellington, and it was very exciting. I have to say, the first day, which was predominantly David, our QC, David Jones, presenting the case, in which I knew I could expect great things from David, but I have to say he really blew us away, and I know that he has a lot of fans out there nowadays, which we tease him no end about because I think it's quite funny. But no, he did amazing.
A doctor I know, an unmarried doctor I know, rang and said, "I think I'm in love with that lawyer in the case."
Oh my God, that's so cool. We've got to pass that on, Katie.
He was a year or so ahead of me at law school, and I didn't remember him like that. He must have upped his game a lot.
I think he's just so
articulate,
relaxed, intelligent, articulate, but also humorous, like in the right places. Like he's just a really genuine guy. And I have to say that one of the things that blew me away was to be at that kind of level in your career and to be so humble and to be, I guess, just so considerate of everybody else, but also considerate of their opinions. I mean, he was very open about taking on our feedback, using our feedback at times, which is like something that's pretty impressive, to be honest, as a layperson. But no, he was just such a neat person to work with, and everyone was totally just such a neat group of people, and of Katie, of course.
Let's move on to that. You've given me personally the spiel about Katie, but describe for people who are watching this what Katie has meant in this case. And just briefly, let's summarize what the case is about if someone isn't aware, although you can go back on the Hood website and you can see exactly the progression. But just a little summary, and then what Katie's meant within this, Sereca.
Well, the summary basically is just, obviously most people watching this know that we are trying to stop the 5 to 11-year-old age groups. I hesitate to say it, and I can't think of another way to say it, but vaccine rollout. So the product that is, in our view, not been through enough stringent testing, etc., and has no evidence to say that is necessary for children of this age group. So, it's an issue that was coming about very quickly after the adults. Then the 12 to 15-year-olds were brought into that age group. And I guess I met Katie right at the 12 to 15-year-old, I think towards the end of that, when I started really wanting to go ahead legally. And I remember, I think you were in that meeting with the 6 lawyers, that first one. I think that was the first time I ever saw you, isn't it, Katie? So we sat around and had this sort of brainstorm with, I was the only non-lawyer in a group surrounded of lots of lawyers, discussing whether we could go ahead with the 12 to 15-year-old age group, because obviously we feel just as strongly about that. It's a different argument. And, the information is very similar to cover off all of the age groups for children. But Katie was, a force to be reckoned with from that moment, really. Starting off just consulting, but then I feel like it's become a bit of a passion project for Katie, and she's put an incredible amount of time and energy and effort into creating this case in which everybody would acknowledge, including all the other lawyers, that couldn't have been done without Katie. So, her chronology, which was David's favourite piece of documentation at the end, I think, which is what he used pretty much to refer to through the entire 2 days, or particularly the first day anyway, but he was constantly referring to the chronology. So that was all Katie, and so were hours and hours of blood, sweat and tears in this particular case. So I guess we've all had our roles, but Katie's has been crucial. So
it's high praise, Katie. That's the pre-publicity I got, that it wouldn't have happened without you. Tell us why this matters so much to you, because it's obviously more than just another professional job. And lawyers put everything into each professional job if they're good lawyers, but it feels like this has got an edge for you. Am I right there?
Oh, absolutely. I'm on a sabbatical at the moment, so getting in and running a massive piece of litigation while I'm on a sabbatical defeats the purpose of a sabbatical, as I'm constantly reminded by my honey. But look, it's really so important. We got lots of nieces and nephews. We're still practicing to become parents ourselves, and we just and I just felt that this decision screened major issues. I mean, this is an entirely new product that's or new class of drug that's being rolled out to a age group that can't make decisions necessary for themselves, but also aren't getting the right information. Their parents aren't getting the right information for themselves. And I've never been a crusader in these kinds of environments before, but this one it has issues from top to bottom, and the fact that the decision was predetermined, the fact that the approval was based on a product that had a different formulation.
A different formulation from the product that was rolled out and put into children's arms. That's horrific.
It is. It really is. So the trial that was used to support the application was for a different formulation for what was ultimately used or approved, provisionally consented to for the children. So it just stunk all the way through. And then to have what I can only describe as absolutely abhorrent advertising, this product's safe and effective. It's been through all ordinary trials. It's the same as any other childhood vaccine. Lies. And it's taken away a parent's opportunity to understand that this is a product that hasn't been through all its ordinary trials. It's a product that's received provisional consent only, not full approval, because it hasn't been through all the trials. And the government is essentially taking away a parent's right to understand that their child could be used as in an experiment.
Well, they're outwardly actually denying it, aren't they? They've said it's not experimental, and that latest little blurb out there about protecting a child for life or something. Well, I can't even remember the exact phrase, but that was just diabolical.
Yeah, and they've just approved boosters.
They've just approved boosters. And then have you both seen in America, they're now rolling out children's songs saying ouchie Fauci or something on the couchie, and it's a little song where, roll up your sleeves and get your jab and ouchie Fauci. It's all very catchy.
Oh, there's Elmo and Big Bird have had their jabs.
So evil. So America is pushing on 100% with this, and here in New Zealand, and it sounds like, Katie, in Australia now, is there a growing awareness, as there has been an awareness growing in this country? Is that happening?
Absolutely. And look, in Australia, it was absolutely, everything was happening very much at the same time. I think that New Zealand even utilised documents from the pharmaceutical registry over here, which is the Therapeutics Good Administration. It's very much the same, and we're running neck and neck in Australia and New Zealand. We just got to get our hearing on before we had a chance to get it on here in Australia. So very much things are running in parallel. 5 to 11s are being vaccinated, not under mandates or anything. Parents still make that decision for their children. But I just think that if parents knew exactly or knew more information, they'd think twice about doing it. And I just had lunch with my girlfriend the other day, and she's got a 5-year-old, and she was just so happy to tell me that for her 5-year-old's birthday, they'd taken her down to the pharmacy for her jab. And I'm just sitting there going, oh my goodness.
Oh my gosh.
Don't you just want to have a chat to me about what this case is about? And I've talked to you about it's a different formulation, not been trialed. And it's like this badge of honour. And I just think that there's enough noise out there right now that people don't have to look very far to find out more information. It's just whether or not they choose to or not. And the advertising is, I think, a big part of how this is being promoted, and it's being promoted by the government. So Pfizer doesn't need to say anything; it's got its sales reps in the form of the government, which is rolling this out and telling everyone it's safe and effective.
It is egregious. And I used my law degree, Katie, after I'd practiced. I used it to get into media. And I used to work in media next to the guy who every night is now on the news at 6 o'clock, who is also part of the pincer movement of misinformation. So we've got the advertisements all day, every day. And at nighttime on our news, we have these ghastly creatures that I used to work with who seem to have left all ethics at the door now, who simply tell the government's narrative, who simply spout propaganda, who ignore 62,000 injured in this country, and who may want to have grandchildren one day themselves. I'm sure Simon's children are old enough to, who are not even thinking of the implications for the future of this country or Australia. So it's a real pincer movement that people are stuck in. On that note, I just want to put a real call out to Kim Hill or anybody at Radio New Zealand, or anybody with any courage left at TV1, both of which places I used to work. Please, if you have any journalistic integrity, would you interview both these women about this court case? Because it is seminal and it's so important that these issues are brought up. Let's move now to the court case itself. Katie, how did you feel it went last week? What was your sense sitting in there?
I think it went as best as it could have, possibly a bit better than what I was expecting. I have to be very honest. I don't, and I've never given us a huge chance of success. But success comes in lots of different ways, and success was getting information that we'd been asking for a long time, and being flicked off as annoyed departments would respond to our Official Information Act requests. Getting answers from the government where, you've got very key players that really refuse to acknowledge any concerns whatsoever. Getting to put in front of them the evidence that is mounting for the severe injuries, to articulate for them what their own information says from the reports to CALM. And that information is information that they get, work through, are aware of. They know there are deaths. They know that there are serious injuries. And it was an incredible opportunity just to be able to have the chance to get that information in front of these people that are making decisions for our country. So I think that is a success in itself. And at the end of the day, successful or not, we are on the public record for having bought this case. And it might not be this time round, but it might be that they start thinking a bit differently with the approval of the vaccine for the 6 months to 5-year-olds, that they might just think that there is enough doubt and enough concern and no emergency that these products shouldn't be made available to these 5 to 11-year-olds or 6 to 12-year-olds or any healthy person for that matter.
Yes. Sereca, of that information that Katie's referring to, what do you think most grabbed the people who were watching? Because there were a lot watching online, sharing online seats and watching where they could, the live casting from the courtroom. What do you think made the most impact in your gut of the information that was rolled out? Shocking people.
I think, to be honest, how weak the Crown's argument was. I think everybody kind of expects to have some really good, solid evidence and argument from the Crown, because when you make a decision like that, that is, going to affect an entire population of 5 to 11-year-olds at the moment and their futures, you expect to be delivered some really heavy-hitting research information and credible analysis. And I don't believe that was there. And I think we were all sitting there curious because, obviously all the lawyers and whatnot, and I had a look at some of their rebuttal, I guess, for their response in their documentation, and been underwhelmed. But I guess in delivery, you thought, okay, well, somehow it's gonna sound better. It's going to have more weight to it in court. And I just felt like, and I keep saying this is the only way that I feel I can actually express it myself. I just felt like it was just smoke and mirrors. There was just nothing actually really there that wasn't already being pumped out. There was no new grunty evidence. And there was new evidence that we weren't privy to, because obviously there were things that Pfizer allowed counsel to see that we didn't see, and things like that, which always makes you curious. And there were things redacted and whatnot. But I think the thing that really probably is shocking is that they didn't provide answers to the questions that we actually had. So we were going into this with a whole lot of questions, and very few of them were actually answered. And that is what blows me away. I guess, even right down to the crux of the finale, really, which comes down to the decision-making part of this, which is what was said in the 4-hour meeting that suddenly changed. Mr. James, director of MidSafe, what was in a 4-hour meeting that was so gutsy that changed his mind from a no, we don't want to roll this out, or we think that this is we don't have enough evidence to roll this out, in a 4-hour meeting that Pfizer was in attendance of. Why did that? And I'll let Katie explain that a little bit more if
Can you take us into that a bit more? That's interesting. Can you take us into that, Katie?
Yes, absolutely. So with a judicial review, it's not a merits-based case. The judicial review, we bring the case, and the case is really looking at the decision that was made of the relevant minister or department. And then in this case, we have Chris James, General Manager of MedSafe, who approves these medicines. He does that on the basis of a risk-benefit assessment. They received Pfizer's application on the 4th of November, and it was further amended on the 12th of November. And on or about the 10th of December, MedSafe said that there wasn't enough information to satisfy them to approve this product. Perhaps it should be recommended off to another committee within MedSafe to review. And that committee reviewed exactly the same material as what MedSafe had reviewed to come up with its decision of no on the 10th of December. That committee met regarding 2 products, which were the new formulations of both the adult and the child's version. And that MAC, which is the committee, reviewed exactly the same information, had a brief meeting with Pfizer, didn't articulate or write down any of the reasons for the change, submitted their review and comments to Mr. James that this product should be approved. And the next thing, Mr. James approves it on about the 16th of December.
That sounds like some sinister American movie with these covert operators leaning on people who can't say no. It just reeks of question marks, doesn't it? It reeks of question marks.
Absolutely. And it's the bureaucrats making the decision. And we've got a situation where we've got MAC and MedSafe that are meeting together. There's more degrees than a thermometer in that meeting with all of the people there. We don't know who the people were that were there necessarily because the names have been redacted, but we do know that there were some pretty big heavy hitters. And they have this meeting. They don't articulate it in detail in any minutes to come up with the reasons why. The risk-benefit analysis appears absent from the material that we have seen. But we've got a no turning into a yes, and the yes is simply a circle on a piece of paper. And, this is 5 to 11-year-olds we're talking about. This is a new class of drug. It's not the same as old-fashioned vaccines where you can know how things are going to behave and react to some extent. This is entirely new class, and it's been whipped through it's just been whipped through. It really has. And it wasn't a case that they had to wait long for Pfizer to provide the further medical information, which was the subject to the conditions on which the provisional consent was made. They didn't have to wait long. There was no reason to not wait a couple of extra months. Children were going to get COVID. In fact, I think I heard the other day from most of the schools that they think that the schools are about 75% of the kids have had COVID already. So, it was going to happen. And they just wanted it pushed through at such a rate and just didn't wait.
But they didn't record any new evidence provided either. That's the thing that blows me away, is that in sort of a meeting with very little minutes and expression of why this changed a mind and no new evidence provided, how do you change a decision? This is the thing when I say that we didn't have answers to a lot of our questions and we're still left kind of shaking our heads in wonderment, is you're still left with but why and how? Like,
so in court, was that not inquired into? Did the judge not pin them down and say, give us information about that meeting? You've got to be more transparent.
They had given us all of the minutes of those meetings, of that meeting.
But redacted? Were they,
just the names and a few other sort of pieces of information. It's really just an obfuscation of responsibility by James to hive it off to MAC, the committee that ultimately said yes. So he could turn around and say, oh, well, the MAC committee said yes, so it was only right for me to say yes.
My goodness. And MAC is what? MedSafe Advisory Committee. Is that it?
Yes.
Something like that, yeah. Yeah, it's this passing of the buck all the way, isn't it? Passing of the responsibility. I'm surprised, Katie, that you're as tentative about your optimism as I picked up earlier. You said we may not succeed. Did you feel that the judge felt a sort of visceral shock at the poor standards, the poor due diligence that was being done on this? Did you get any sense of reaction from the judge?
Good question. Look, we had a judge change late on Thursday, so this was the weekend before, the week before Matariki weekend, and we had a change last minute. From the morning we had the judge we were always expecting to have, and then in the afternoon we just had a new judge. And so we've got... That was
Justice Gwynn to
Justice Gendel.
Gendel. That seems very odd. What was the reason given for that?
None whatsoever. We never got to the bottom of it, and I was quite concerned about it. I was quite concerned the late change, no notification, and who we were changing to. But in hindsight, and with the experience of the hearing and having had the interim hearing back with Justice Ellis in January, we certainly got, I believe, the best judge to hear our case. I think one of the girls messaged when Justice Gendel said that he hadn't appreciated that the vaccine was a different type of different class of vaccine now, and everyone was writing, messaging, saying, "I'm aghast. I don't understand that. He could not realise that." But to me, that was fantastic because we get a blank canvas, and he was across so many things. He was across the Swedish approach to managing COVID from a public health perspective, and he was attentive the whole time. He gave us the same respect as he gave the Crown. Very different situation to what we had when we had Justice Ellis in the January interim hearing, where we just heard that the parents were anti-vaxxers, and I don't even think that she had had a chance to read all of the material that we submitted in support of that case. But Judge Gendel has said, he wants to review everything. He's got thousands of pages he needs to review, but he gave us the sense and impression that even though he'd come on late to the case in the afternoon and had really only had a chance to read the respective parties' submissions, he was very interested to read further and to learn more about this. And so while he might not be making a decision on the the merits and things like that, he'll be looking at the risk-benefit analysis that was adopted, and then the rules around the Medicines Act, which the spotlight is on.
You also,
sorry, Sereca. Yeah,
I was just going to say about just an observation from a layperson's perspective as well, is that I was really impressed that he would really take the time to ask David questions and make sure that he understood clearly what was being presented. And he did that multiple times. And he also seemed very unruffled and unimpressed by any sort of legal game playing, in the sense that he was not at all, fooled by our experts being kind of downplayed. He respected Dr. Malone's credentials and his experience. He also, saw past that, yes, okay, Dr. Gert van den Bosch may be a vet, but like he has an awful lot of other credentials after that. And I really enjoyed the fact that he was not really going to be pushed around in terms of like, yeah, okay, can we stop playing these games? Can we get on with this? And I found that really reassuring, that he was genuinely interested in really truly getting down to the nitty-gritty of what the argument actually was. And I think it would be very easy for a judge not to. And the fact that he really has expressed quite an interest and a desire to understand, regardless of whatever the outcome is, I do believe that he appears to be giving it a really fair appraisal.
He will be an absolute hero if he can remain neutral in a climate where, as someone legally trained, I have been despairing, Katie, because some of the judgments we've had have made zero sense, apart from the one that the people in the street take, which is, are the courts being lent on by a corrupting government? And that I just put as a question. We don't know, we can't know, but it is what the people are saying, and the government and the judiciary need to be aware of that. People talk in this country and we share notes. So you can't get away with it in a small country of 5 million. So let's hope that he is neutral and fastidious and ethical beyond belief, which all judges are meant to be. And he will be a hero if he keeps to those three standards, so gold standards. Having said all of that, Katie, back to my question, why your tentative sort of tone of, I hope that we could get somewhere here, but if we don't, we have had other wins from doing this case. Why tentative? Any advice that I would give at the moment has to be in the context of what you were just alluding to, which is we've got an environment where the judiciary believes what they are told. They very much have made their choices in respect to being vaccinated, probably to continue to do their job, or because they themselves believe what they are told. And I think that is a terribly important environment in which context needs to be given for what the deciders or what the decision makers are working within. And everybody's got a view about COVID. Everybody's got a view about the public health measures, and everybody's got a view about being vaccinated or not. And I'm sure you've seen it too, Liz. There are so even few lawyers out there that have taken a particular position or perceive this to be a loss of our rights. All my girlfriends, for example, that I've practiced with, they're on the total bandwagon about the recent abortion decision in Australia, in America. But I'm just saying to them that bodily autonomy was stripped as soon as the vaccine came about with COVID. So, wake up. It's an unassailable point. And yet people just look blankly. They can't seem to put those two parts together. I know that in New Zealand, the New Zealand Law Society was, just as the Medical Council has been subverted to the government narrative, I'll call it, which is a lovely way of saying something else. But they've been leaning on lawyers. It's horrifying how few lawyers have come forward. As more and more injury cases show up in this country, they will need to really turn a large part of their practices to helping the injured. That's my belief. That's my prediction. So they're going to have to wake up.
Well, the injuries are coming. Sorry.
Yeah. Oh, no, I was just going to say the family court is probably one of the most shocking ones that I've actually found in this sense of buying into all of this and being so incredibly bound by the government decision. Because I know up in Auckland, for example, I've been working and advocating for lots of people, and it was actually the judges that got together in Auckland that stated that unvaccinated people would not be allowed into the courtroom. It wasn't an overriding law anywhere. It was the judges who got together to make that decision, because you could go into other courtrooms in different parts of the country. So
I
you're already...
did not know that, Sereca. That is absolutely runs counter to justice for all. Completely.
Well, it doesn't really put you in a great standing when you take a case that's anti that position. Shouldn't use the word anti. God, you go into like too many pigeonholed responses there. But it immediately you're on the back foot, aren't you? If you're going into a situation and you've got to be on a Zoom call or whatever, because you're basically stating you are forced to state that you have made a decision not to take a medical product. I mean, the whole thing's just backward in so many different ways. And I think the thing is that you talk about that blindness, Katie, in terms of the hypocrisy, really, and people just not connecting the dots. And the other thing that's been sort of blowing me away is this past week, with the Pfizer being in the media again about the blood pressure medication, and then literally publishing and stuff that there are more questions than there are answers. And that's a statement that I almost can verbatim read, because it kept going through my head, because I'm like, yeah, but we've been saying that for months, and then, somebody else said, it feels like we're being told half truths. And I'm sitting there going, but we've been saying that for months. And it just feels like finally there are other things coming out. And I know Chantal Baker did a stream of all of the things, all of the cases in which Pfizer has actually been brought up under judiciary.
I heard about that. I heard it's very good. I've asked someone to send me that.
It's really good, because she just lists them all, and quantity of money and whatnot that they've had to pay out for all of these cases. And we know about them. But the thing is it's not being publicised. Nobody's ever stopped and thought, these companies have paid out billions of dollars in lawsuits. There's no surprise we're sitting in another lawsuit right now. But the thing is that, like Katie said, we haven't lost regardless of what happens, because the awareness is getting out there. And the fact that we are actually taking, forcing our government to become accountable for those decisions that they made, and to trust companies that do not have a great history.
Not a great history. They are the most criminal big pharmaceutical organisation. They have had the biggest award ever in the history of awards against pharmaceutical companies. And people need to research that. If you could send me that would be great. I'll add it underneath. Yes, Chantel's. Just getting back, Katie, to our law school days, I imagine you, like me, were also taught about constitutional law, and that the judicial arm in the end is there partly to keep the executive arm, the politicians, honest. We need this in this country, and I imagine in Australia, more than we have ever needed that constitutional protection. Would you agree with that?
Oh, absolutely. And I recall when I was going through law school, that I could never quite understand the position, which was, our Bill of Rights, it's an act, but it's not yet a constitutional document. But don't worry, the government's never going to do anything that goes against the Bill of Rights Act. And that replays in my head while I was sitting down in my public law B lecture. And I just think to myself, goodness gracious, I was involved in the midwives case as well. And, constitutionally it reeked. And we still had the son of the judge that wrote the book on Bill of Rights Act, and how important it was as a constitutional document, albeit it hadn't been properly seeded as such. And we've got him making decisions against the very core of what the Bill of Rights Act is about. So
no.
I think a constitution is certainly necessary. The sovereignty of the courts and the division of power, I think, is really important. There's certainly tensions within the courts at the moment, with a recent suggestion that some things need to be investigated as to the separation of powers and undue pressures being put on. I'm not going to say that we have that in this case. I really do think we've got the best judge for our case, and he's I felt that we all received the respect that everybody deserved, which we'd all worked so hard to get there. We'd all put our best case, and the Crown did too. I think our experience of David Jones, or his experience, certainly outweighed the performance for the hearing, and he was an absolute joy and pleasure to watch. It was exhilarating.
He said something interesting too, Katie, and it was just touching on the outcome. And it was something that I hadn't really thought of. I knew that everything would be made public record, but the comments of the judge in the ruling can be just as powerful as a win or a lose. And that was a really interesting point because it was not something that I kind of had thought of, but makes total sense. And with some of the experience that I've had in other legal matters before, that commentary, that comment for public record is pretty powerful. And some of the things that he seems to be taking on board that may be in that ruling, that could be quite powerful too, couldn't it, Katie?
Absolutely. I think we call that obiter.
Obiter dicta, yes.
And so he would then be able to, we can then quote him left, right and centre if he says some good things. And look, I know a lot of family court cases are waiting for the outcome of this case. And there's some rather odd things that are happening in the family court environment where, the court itself is looking to put on expert evidence because there's no counter evidence that's been put on. And I just hope that certainly the family court has the ability to have some good references for future cases that are brought, because there are a lot of vaccine cases and applications being brought in the family court, and it is down to the family court judge at the end of the day, but there does need to be some good decisions out there that mean that there is equal consideration given to both sides of whether or not this product should be administered to children. And look, I'm sure if the judges in the same way received full informed consent about the nature of these products being a new class of drug, it's not that it is different. And just quite where it is up to in the stage of the trials and testing and reports, I suspect that those judges too would be really thinking hard about whether or not they would be making decisions that could put these children in jeopardy. And it was incredible that we had the situation on Tuesday of the hearing where, it's thrust down our throats that it's safe and effective, And then, we get this almost turnabout on Tuesday, which was, every drug comes with its risks. And I'm like, well, it's not bloody safe then, is it?
That line is so cynical. That line is so cynical. A doctor told somebody I was interviewing, "Thank you for taking one for the team," a jab injured person. That thinking, that warped thinking has penetrated into the medical professionals who are short selling these injured people who are so traumatized. It's unforgivable. No, it is not okay. We used to stop at 50. They stopped the rollout of the last SARS vaccine because 50 got injured. And we're now at 62,000. That is not okay. That is just not okay.
I think there's other forms of injury that we're not addressing as well. And it's the psychological injury and the injury that's happening within the family courts. And again, I keep coming back to this because of the fact that I'm in contact with so many people in it. And one of the things that I hope that comes from this ruling, regardless of whether it is a hard win-lose situation, is that information that it is a valid argument, because people are actually having their children removed from their care over this because they are considered so far out and so down the rabbit hole that they are actually being kept from their children over a decision to take a product or not. Now, that in itself is an injury. That's an injury to the relationship between a parent and their children and vice versa. And I'm not going to compare that to a physical injury, but that is actually like absolutely heartbreaking. was talking to somebody yesterday and just got off the phone, and I couldn't shake it. This situation where a parent is kept from their children with no justification. I was like, but why? What is the argument that they're making? What is that? I don't understand how they could do that. And it's basically because you're considered a freak because you're going against, this. And to have this case out there that has legal credibility and acknowledged by a judge as having legal credibility, win or lose, that to me has some power in it. I hope. I am not a lawyer, so I'm purely stating this from somebody who's watching horrible stuff happen, and I want to help somehow.
What do you think, Katie? I think it can help if he gives those comments, even if he says I'm constrained within certain parameters. But if I were not constrained, I would think this. That could be very powerful. Absolutely, absolutely. And I think so many people are looking towards the case for that, and certainly we are too, because there could be a lot of vindication in those comments. So it is a strange case because we put forward expert evidence. That expert evidence is contrary to the evidence of the witnesses that the Crown rolled out, and there is a lot of different view and consenting positions on this. It really is a chance to get the information before those people that are making the decisions. So that in itself could be a win, because they may just choose not to approve the 6 month to 5 year old product with the information that's been put forward. I doubt it, but there could be enough doubt that is put in their minds that perhaps this is not needed. I think there's a step before that Sereca identifies, which is you make more people in the public arena aware of the issues. They then put pressure on the politicians, who will always crumble when enough of us stand up and say we're not okay with it. So it's educating. We, the people of New Zealand, need to be educated.
We win if the uptake is low. We win if people don't go out and get it, regardless. So,
Katie, what are you a Kiwi originally? Are you? Yes, I'm exiled. All right. Okay. I was just thinking, I think we've lost a great resource here. I was just imagining you in years to come on the bench, dispensing real justice in real courts of law when we've recovered them.
Oh, Judge Katie.
Yeah. What are you doing over there? Are you now working on a similar case in Australia? So part and parcel of meeting some of the amazing souls that I have on this journey and interviewing all of these experts and meeting with them and directing them to produce these fabulous reports that they've done for our case in New Zealand, I came across the Australian contingent. And so in Australia, the group here bought an application for judicial review of the 5 to 11-year-old decision, and then similarly a separate action which was to require the decision maker who approved the product in Australia to reconsider his decision in light of huge fatalities, massive injuries, and the fact that the product's ineffective. And as a result, I got brought on board in Australia to be instructing solicitor on that case when one of the other instructing solicitors took paternity leave. So unintentionally ended up running the Australian case, which is in the federal court, and being involved a lot more than what I had originally been told I would be, because we have had a few barriers and blockades put up in front of us in the Australian case, such that the judicial review for the 5 to 11-year-olds here in Australia was to be heard on the 20th of April, but there was a decision before that to find that the applicant didn't have standing, so didn't have the power or the ability or a right to bring this case. So we're currently appealing that decision to the full bench of the federal court. Even to get in there, you have to go through a process of appeal. What on earth was the reasoning that you didn't have locus standi? What was that?
There was a couple of different reasons, but first and foremost, the AVN, which is the applicant in that case, is was bringing the cases, and there was a finding that because of that it wasn't the foremost anti-vaccination body in Australia, and therefore it wasn't entitled to bring this action, and actually had no loss or if it was to succeed in bringing this application. So
that's the Australian Vaccine Network, is it? The Australian Vaccine Network. Oh my God.
Australian Vaccine Risk Network.
Yes.
So yes, that was a very surprising decision. There's a few other nuances in there, but the other one, which was interesting, because at the same time they sought the opportunity to join a foster father from Adelaide, so that if the AVN didn't have standing, then a foster father who's lost his job as a consequence of the mandates and has a foster child which has been directed to be vaccinated by the state, and he didn't have standing either. So really quite incredible. That's under appeal. We'll hopefully have that hearing in early August.
I ask that because it's important for Kiwis to realise what battlers you both have to be to get where you've got in New Zealand, the number of hills you've had to climb. And here you are, Katie, now turning around and climbing another series of Himalayas over there in Australia on behalf of this issue that matters so much to you. You'd give up all your sabbatical, your time, your energy into it. I really want to commend you both. Sereca, do we need more funds so we can pay for the quality of a Katie on this case? And if so, do we just need to put a message on that?
We do. It's usually Katie in my ear about that. And also Nicola as well, because Nicola's the accountant, and so it's usually them going, don't forget to mention. No, we do, because the thing is that, and I've said this before, but the weight of the case that we brought forward was absolutely huge, and the power and evidence that was brought forward by those experts and the incredible legal team that we had and whatnot, it just wouldn't have happened, if we didn't have some funding to do that. You just cannot expect the thousands of hours of work and weeks of report writing and reading, and I gained so much more respect, to be honest, watching the suitcases of paperwork come into the High Court. And we did have a giggle as we saw the Crown come in, because we thought it was another 3 that had gone in prior. And then we saw the 3 with the big trundle cases of suitcases. We went, oh no, that's them there. So, it was very evident the amount of work that had gone into it, just in literal paper sense, and the printing, and just, I'm not saying that printing costs hundreds of thousands of dollars, but it did really actually put it into context for me as well, the amount of brain work and physical work that's gone into this. So no, we haven't paid all of our bills yet. We have gotten a long way, and through everybody's help, we've managed to get to court, which was the first hurdle. So that was amazing. Now we just need to finish off, because obviously we had replies to the Crown. We had lots of different last minute hustle to do this, that, and the other thing. So it's not a cheap exercise to go to High Court, and but we did it on what I would consider a shoestring. I think with Katie's help in the epic work that she put in, and the voluntary status of everybody else in the hood, we've managed to pull this off with the actually remarkably low funds. I know that the case in Australia is like at least 3 times what we are actually funding. So we do need.
I would endorse that, please. If you can spare $5, $10, $100, $500. Put in what you can. We'll put the link to the hood, and there you can make your donations. We'll put that at the end of this. And Katie, I just salute you. Thank you for coming on and sharing how important this case is. Salute you for being a part of this and doing it in Australia. And I look forward very much to an absolutely positive result. I'm allowed to say that. You two can't, but I can.
I can.
And that this justice comes through and does the right thing on the basis of the evidence, which is that there was really a lack of evidence for the rollout for these future generation of children. Thank you both so much for talking today.
Thanks, Liz.
Cheers.
Thank you.